satisfied that in the event of emergency, a truck can get down there and fight a fire?
And as a private drive, there's no need for sidewalk and curb.
That's certainly up to you, but
Curbing, I'd like to see.
that's,
Well, on the south side.
So in the event of an approval, we're not usurping, so to speak, this access.
If I could add one more thing, this right of way is only 40 feet wide, and the law requires only 50-foot wide roadway through. So how the board views that, as it lends itself better to be a driveway, since the standard roadway width would be difficult to truck in that right of way.
And just for the board, I agree, everything with your counsel has guided you on, and that's why we said in the beginning that if this board were to grant the relief that the applicant is requesting, that obviously it would be conditioned upon that.
and it's not, and I'm not by any way advocating their position. What I'm saying is that in front of the board, that he's chosen his proposed access.
You just
And we're not
clarify
gonna
the
fight,
issue.
and we're not gonna fight him over it. Is it adequate for emergency vehicles?
Mhm.
Let's say, for example, he says that he has illegal access along that 10-foot. And the owner of the property comes in and says, no, you don't. Well, interestingly, in the same vein, the exact issue is in that little book that you got today from the planner. That this board does not adjudicate title interests, easement interests. You're not the man or woman in the black robe and freehold to decide whether that 10-foot strip, he can really go across it.
We're not the Chancery Court.
Right, you're not the court. And in this new case, Mahoney versus Brick, all the cases before then, they talk about how you're not, that's not your call. Your call is, they're proposing access under the jurisdiction of another agency. Your jurisdiction is to make certain that a truck can drive in there and fight a fire if they want to get that close. That's your job as the planning board. So, I'm not trying to say you shouldn't be making decisions, I'm just trying to keep the record clear. And it's a kind of unusual apparently for Spring Lake, that the Spring Lake Heights, that this happens. It's not an infrequent thing in some other towns.
If it's 15 feet wide rather than 10, I think it would be better.
It's not a road. Remember, it's not a road.
I
Still a
understand.
driveway, but 15 feet's more than 10.
The place that we're using to drive in here, that gray area, is 15 feet wide rather than 10, which is the 10 is just the easement.
That's an argument for the applicant, or the way you make your decision, balancing the merits of the application.
Not only that, in terms of fire trucks, this condominium parking lot is very close access to both of those homes.
So they're probably not.
Any other questions?
Public.
Let's open it up to all the folks if they have questions of the engineer. State your name. Guess who?
Hi, everybody. For those of you who don't know me, my name is John Brennan. I'm an attorney. My office is on. Hi, everybody. Hope everybody's paying attention. For those of you who don't know me, my name is John Brennan. I'm an attorney. My office is at 43 Main Street in Avalon by the Sea. And I represent Gary and Judy Skellinger, who are the property owners at 524 Highway 71. They object to this.
Just for my own application, Mr. Brennan, I'm glad that you were able to make it this evening.
Yeah,
It's really good.
I really wish you wouldn't have brought that up.
Well, I just want to know, is this
But, you know,
block
that's-
73,
I don't-
lot 7, the property, is that your client's property?
Sure.
No, I just want to make sure, I don't have the street addresses. It's block 73, lot 7?
That's what I'm sure you know that, Council.
No, I don't, I'm asking.
Block 73, lot 7.
Block 73, lot 7. Okay.
As we discussed on the phone, before you told me that you would not grant the courtesy.
All right, by
No, no.
the way, I'm jumping here. Mr. Brennan, you said you couldn't make it, you're here, that's great.
Great.
Let's move forward.
I have a document that you have marked.
Would you want these exhibits in cross-examination or do you put a case on?
Can.
Okay, I mean.
Well,
whatever
I'm gonna
you
see what the, John, could you show it to
Yeah,
council,
let me see
show it
what
to
it
me?
Sure.
You
For
can-
purposes of cross-examination.
have to, this looks like it's about 250 pages long.
159. to be exact.
159?
They're all labeled. Down at the bottom, it's kind of small print, but because PDF came out that way. Down in the bottom, in the center, if you look, you'll see SLH, UP, 800 subdivision, Skillinger, dock.
Yeah.
It has a number,
Okay,
and they're all in sequence.
so this is, I'm gonna mark this as 01, and all the pages are marked SLH-PB, Ahern subdivision, Skellinger dock, 1 through 159. Is that fair to say?
Yes, and I've brought sufficient quantity for the board members.
Pardon me?
I've brought sufficient quantity for the board members if I could distribute them.
Sure, well, you have to lay a foundation for their entry into evidence before the board looks at it, so,
Okay.
so if he says, I don't know what this document is,
Well, they're all public record.
I don't see a affidavit from a custodian of public records, Mr. Brennan, so,
Okay. Mr. Stewart, according to,
Do we mark this in?
You gotta speak,
I'm a little confused.
this is marked as 01,
Yeah, so-
okay? You're gonna come up to the mic, I think, because we need,
we need it at the mic.
okay.
Yeah,
and then,
And do we have this,
if the board's not gonna see it until we identify what the document is.
or do we have this affidavit that this is,
and what
Well,
is,
I gotta see what Mr. Brennan, how he gets this, lays a foundation for these documents.
I'm
Mr.,
using
for
for
example,
purposes of cross-examination.
if Mr. Stewart says, I don't know what this is,
Okay,
then the board's not gonna see it until you authenticate it,
okay.
right? Look at this.
My position is that it's an authenticated document because it's in public record. And it contains documents which are and can be identified by the applicant.
Well, we'll see when you ask him.
it's 159 pages, and we haven't had enough time to go through it.
Why don't we just ask some questions and see if we can move
That's
it
what I
along?
like
There
to
you
do,
go.
yeah. that's
Okay.
good. Thank you. All right, Mr. Stewart, you have very impressive credentials. You testified about the due diligence that you conducted with respect to determining the ownership and the various requirements of the zone. My question to you is, how did you determine, for purposes of standing, who did you determine to be the owner of this property?
Oh, can I just say, for purposes of standing, what do you mean by that?
He's a contract purchaser, correct?
Yes,
Okay.
so I'm just saying
And
standing.
he's a contract purchaser.
I'm not, I just don't understand the term standing. When you say standing, are you saying that somehow Mr. Stewart, if you asking him a question regarding, what's the
he's asking
standing
a
question? I don't understand it, so I don't
Who did he
understand.
determine to be the owner of the property? You testified that he did a title search, he did a bunch of
Are we talking about
information.
your client's property or the subject property?
The subject property.
Okay, I'm just a little confused. Okay. So Mr. Stewart, you know who the owner of the subject property is?
And the owner was Mr. Ahern, and
How
now
did
it's
you
in,
determine
and
that?
now it's in the estate of Mr. Ahern.
How did you determine that Mr. Ahern is the owner of the property?
From the, first from the contract, from the purchaser.
Okay. So you're the purchaser?
I mean, from the owner, who it's in the estate of Mr. Ahern, and the executor is Mary Ann Kelly.
Okay.
So, and you're under contract, just for clarification, with Mary Ann Kelly as the executrix of the estate of Ahern.
Correct.
Okay. If you could, if I could direct your attention to document 141.
Okay?
Do you recognize this document?
I do, yes. I
Can get-
believe it's the death notice. Okay.
In fact, you provided this document to the board part of your application, correct?
I believe I did, yes.
Okay. And what this is it's a letter appointing Mary Ann Ahern Kelly as the executrix of the estate of Donald J. Ahern, correct?
Hold on, so, I realize the rules of evidence are relaxed. What I'm looking at is a copy, a document that's not an original, it's not sealed, there's no indication that this is not anything but a copy.
Can
It's
I
stated
can I just
copy.
interrupt, can I just
Yeah,
interrupt for a
yeah.
minute? I don't apologize if you're not used to a lawyer jumping in, but could you give just a proffer of what,
What is it?
are you saying that there is an issue as to who owns this property? Okay, so that's completely irrelevant for purposes of
Right.
planning board,
Right, right.
We're far
because
afield.
we have a municipal record that reflects an owner of the property, we have someone who has issued an application, and whether or not there's a cloud on title and other claims to the property, or just like the access issue, that's something way beyond what a planning board does. We have a certified, a person with a license, who said they did a title search, they determined the owner,
And I'm cross-examining.
but what difference does it make?
Okay.
If he doesn't own it, then he won't, if he.
I'm not asking, no, I'm not saying he doesn't own, he has a contract, he's testified he's got a contract from Marianne Ahern Kelly,
Right,
who's the executrix. of
and we're not
Donald
gonna
J. Ahern.
determine if that was the proper owner that signed consent to this application. Is that what you're trying to say?
No,
Okay.
what I'm saying is Donald J. Ahern is not the proper owner of the property. That's what I'm saying.
Who is the owner?
The owner is Ahern and Ahern Partnership.
Okay. And how does that affect this application from a planning board perspective?
The zoning law requires that the person who comes before the board have the appropriate standing to be able to make application for relief, correct?
Yeah, well, he has the consent of, he needs to have a prima facie showing of the consent of the owner if he's the contract purchaser, which the board noted as part of their acceptance of jurisdiction. If the owner is not the owner, well,
Then
okay,
there's no jurisdiction.
then there's no jurisdiction, then that's never waived.
Okay, well then I'll stop.
But that's never, I mean, that's never waived. If that's not the owner, that's not the owner.
Okay.
Right.
Did you want me to proceed with the questions about the ownership, or you want to just risk it?
What do you, Well, you know, Mr. Brennan, you're not risking it, but I'm telling you, what I'm telling you is just like, let's say the owner, your client says that 10-foot access, he's not entitled to go across that. I'm gonna tell the board, we're not interested in that, okay? Which I'm telling the board now, we're not interested in a dispute over the title to this property.
Right.
Okay.
And we're
It's not our
not,
jurisdiction. Carry on.
You don't have any jurisdiction if you don't have somebody here with proper standing.
But we don't have jurisdiction to determine who the owner of the property is.
Nor do you have certified copy.
No, that's fine. I'm asking questions.
I understand that, but let's stick to the application.
That's fine.
and I'll just let the board know through, Mr. Stewart will testify right now. Mr. Stewart.
No, hold on, we're not, Mr. Brennan's turn.
Okay.
Can't,
Thank
yeah,
Can't jump back.
Mr. Brennan's turn.
Okay. Do you know whether or not, how lot 4.02 came into existence?
I have a document,
Okay.
I have a
Did Johnny make a
document,
profit for this?
He's answering your question.
I have a document that's entitled Proposed Subdivision, Block 73, Lot 4, Borough of Spring Lake Heights, Monmouth County, New Jersey, prepared by Walter Hardington, Inc., dated October 26, 1986.
Okay. And who is the applicant on that? Do you know?
I do not know.
Did you make any effort to try to determine who the applicant was?
No.
Okay. Would it surprise you to find that the applicant was in fact Ahern and Ahern Partnership?
Excuse me?
Would it surprise you to find out that the applicant at the time was Ahern and Ahern Partnership?
No.
And that this, we're talking about the subdivision that created we talked about the subdivision that created the condominium complex, which is located at Monmouth Avenue and 71, correct?
Yes.
Okay. And that subdivision, which was granted by the predecessor board here, created that lot, which is where the condominium is located, and continued with this particular lot, correct?
That's my understanding, yes.
Okay. And that was common ownership, correct?
I believe, I was told that Mr. Ahern owned all the property around here.
That's right, Mr. Ahern owned a lot of property around there, correct?
Yes.
But I'm talking specifically about this specific subdivision. This lot came into existence by virtue of a subdivision which was conducted by Mr. Ahern, right? Through Ahern and Ahern partnership?
He said he didn't know.
I don't know who the
He
applicant-
said he didn't know.
Okay. No, I'm asking about the subdivision.
Yeah, I don't know who the applicant was. I only had the map.
So you made no effort to determine who the applicant was?
No. There was no need to.
If I could direct your attention to document number 99, excuse me, number 33.
Are we still, Mr. Brown, I don't mean to be pester, but are we still talking about who owns this property? Do
No.
you think it's Ahern and
No,
Ahern?
no, no.
Oh, okay.
I want to establish that this was created by way of the state, the subdivision. This particular lot was created by Ahern and Ahern.
Well, no,
Oh, wait, it's up.
are you sure about that?
Yes.
Because if you look at 144, which is the granting of the subdivision was to a guy named Donald Ahern.
That's right.
And that appears to be the same, that's the deed arising out of that subdivision, right?
That is the resolution, and this is the deed.
Okay.
Okay. Which perfected the subdivision.
Right?
Now, Mr. Stewart, my question to you is that, have you seen document number 33 before?
I believe I have.
Okay, and is it part of the title search that you referred to previously?
I'm getting confused, okay.
Right. But you gotta answer the question, Mr.
Well, I don't
Stewart.
understand, because he says document 33, or
Okay,
what's
there's
this?
page 33, he's marked 1 through 159.
And what's the other one?
I
you
thought it
just
was number
referred to?
99 that he said.
No, he said 33.
Oh, I'm sorry.
Oh,
Okay, so no,
33.
we're looking at 99,
Yeah,
that's
we're
what he
looking at
said,
99.
so.
So let's start from scratch then. Do you need to recognize that document?
I'm gonna tell you in a minute. I have to say that I reviewed these documents months ago. And this looks familiar to me.
Okay. Document 33, if you just read the paragraph that begins, the aforesaid premises,
Yes.
okay, was subject to a minor subdivision approved by the planning board of township of Neptune, which is obviously an incorrect statement, but it attaches subdivision map, correct, which is the next page?
Yes, sir.
And you recognize that based upon your
Again,
learning?
we're going on assumption of the original, because you don't know. These are just copies that you were presented to this evening. So there's been no we're just gonna put that on the record, that there's been no verification. We're going on an assumption that these are somehow original documents, or copies of original documents. We don't know that. I don't.
Okay, I mean, it has a deed book number in the
Right.
sector, so unless Mr. Brennan's really good at
Mhm.
forging stuff.
There's no need to do that.
So I'm still just trying to get to the,
To understand why we
well,
did this.
we'll get there, we gotta get there at some point.
Okay, so, this particular deed dated September 15, 1983, perfected the subdivision, which was granted on August 30th, 1983, by the planning board of the Borough of Spring Lake Heights, correct? Look at the map.
Okay.
Uh-huh.
You agree, correct?
That's what it purports.
Right. And so, 4.02, which is set forth on page 34, is located right there. That's the subject property, the subject of this application, correct?
Yes.
Okay. And the lot just to the north of it is the condominium property, correct?
Yes.
Okay. So the application, this particular application created this particular lot, correct?
I believe it, yes.
And you are familiar with the fact that boards, municipal boards, are entitled to take into account self-created hardship, correct? You've heard of the concept self-created hardship?
Yeah, well, I don't,
Oh, if he's capable of answering in his expert opinion, he is. If he's not, he's not.
Yeah.
Okay. And what a self-created hardship is when essentially the board has the power to say no to an application based upon hardship, where the hardship was created by not only the applicant, but the predecessor in title to the applicant, correct?
I don't know that.
Okay. Counsel, you agree with that, right?
I'm not, he's an engineer.
Yeah.
I wouldn't think the engineer would testify that. I think you'll have that discussion with the planner.
Okay.
If I was an engineer, I would talk
Okay.
about it.
That's fine. Now, the present ownership, you say, is with Mr. Ahern, perhaps maybe Ahern Partnership, but you've testified many, many times, right?
Yes, I have.
And you've been an applicant from many, many boards, correct?
I haven't been an applicant, no.
You've been an applicant before the four boards.
I have.
Now, and you've testified that you are familiar with the concept of self-created hardship.
He said he wasn't.
he wasn't,
I've
he
done.
wasn't.
Oh, yeah, okay.
So I'm just gonna.
I'm certainly not an expert in it.
Right.
Well, you haven't heard it, or you're not an expert?
Okay, let's just relax for a second. Will you give him a second, ask your question, give him an opportunity, take a deep breath, and hear the answer. Don't let him put words in your mouth,
Mhm.
because that's what
All
I
right,
said.
come on.
Yes.
You recognize that you, as the contract purchaser for whoever the owner is, right? Presuming the owner is the,
We're gonna stipulate, Mr. Stewart, are you the contract purchaser with the owner of the property that's the subject of the application before this planning board this
no,
evening?
not stipulated. I'm not
No, we
stipulating.
can stipulate to that.
Okay, well, you can stipulate to all.
Yes.
Hold on a second.
So,
Can I just jump in
stop.
here? We don't care. Right, and Mr. Brennan, just so you understand, you're saying, I'm looking at Ahern and Ahern, the limited partnership. I'm looking at the fact that somebody named Donald Ahern is dead.
Right.
And if he was in that limited partnership or controlled that limited partnership, then obviously his executor is the one that's supposed to sign the contract. So I don't know where we're going with Ahern, all this stuff. I can understand your argument on self-created hardship, that's fine, you got it, but that's for the plan. But the whole thing about owners and who they are,
No, I'm not arguing about that.
Okay.
My point is this. My point, and I'm trying to ask questions rather than make points.
yeah, well, I'm trying to, I don't know we're trying to figure out where you're going. So I got 159 pages the day of the hearing.
So that's why we
Yeah.
wanted to put a stipulation to the board. I'll put to Mr. Stewart that you are the contract purchaser for the property that's the subject of the application before this board this evening, correct?
Yes.
Okay. And as part of that contract, it is contingent upon the seller conveying marketable, insurable title to you, correct?
Yes.
Okay, thank you.
Okay, that's fine. That suits me. Okay, now, with respect to, you testified with respect to Lake Drive, right?
Yes.
And you heard, in fact, your counsel said that she agreed with Mr. Collins that Lake Drive is a municipal right-of-way, that, and there was questions about ownership of Lake Drive, that it comes into existence by way of a dedication, correct?
Well, not necessarily. Okay, you're mischaracterizing what I said, Mr. Brennan, and that's really not good.
Okay.
What I said was that it's shown on the records as municipal right-of-way.
Correct.
Depending upon the year that it may have been created, it may have been, there were alternative methods over the course of the last 100 years that public rights-of-way were considered dedicated to municipality. Because we use the word dedicated because it's not conveyed, it's dedicated. So the use of that word dedication, like now, if they file a map that shows the road, that's an offer of dedication.
Okay.
So I don't want to put words in my mouth.
Mr.
And all I
Collins-
said was that whole issue of the existence of that right of way and access along that right of way is not our business, other than to make sure they're okay, with the fire truck going down the driveway.
I'm cross-examining with respect to what his testimony was,
Okay?
and his testimony was that he determined.
I won't argue with you, you said that she agreed with me, we weren't talking about Mr. Stewart as part of that conversation.
Mr. Stewart, you recall your testimony about looking into the right-of-way?
Yes.
Okay, and what did you find out about the right-of-way? How did it come into existence?
It's a municipal right-of-way shown on the municipal tax maps,
Anything else?
and that it's also shown on the mapping that I was able to obtain for this area.
Okay, when you're talking about mapping, are any of those maps recorded and filed maps?
The one that you refer to, the subdivision map.
The subdivision map does not contain the creation of Lake Drive.
No, but it shows the road. It shows the road.
It shows,
It shows Lake Drive.
it does not actually. Number 34, it's not show Lake Drive.
Says it right on the map. Says
So
Lake
let's just
Drive.
point to what you identified.
Well, pull the page up. so you're-
It says
Yeah, we're looking
Lake
right at
Drive,
Lake Drive.
40 feet wide, unimproved.
Oh, yeah, check that out.
Yeah, right there.
Okay, to the west of this map, right? Presuming Lake Drive continues, have you made a determination whether or not that, how that came into existence?
I'm sorry, I don't understand it.
Well, I'll withdraw the question. You're proposing to gain access to the property over a driveway on what you claim to be a municipal right-of-way, correct?
Yes.
Okay.
This-
Can we
No,
have,
no,
can we just have some
Counsel,
testimony
you
directly?
you have to let him answer the questions. You can't feed him his answers, or let him concentrate on this so we can get through this. I mean,
I agree, I'm not feeding him the answers.
but there shouldn't be any discussions among counsel and client during the process.
The
Unless you
rules-
want to object to the
I
question.
respectfully agree to disagree. The rules of evidence are relaxed before this board.
Oh,
So I haven't, if this is not a
He's not
deposition,
he's not
I have
asking
an
you a
opportunity
question.
to make sure, I wasn't able to prep a witness like you were for a deposition. So I want to make sure that my client is fully understanding, and when the attorney asks
He's
him
a
a
smart guy.
question-
If he doesn't understand the question, he should say, I don't understand the question.
Well, I have to be able to speak to him and tell him, to advise me.
If you don't understand the question, Mr. Stewart, none of us want you to answer it, okay?
Okay.
Including Mr. Brown, I'm sure.
Okay. Mr. Stewart, your proposal is to gain access to the property over a private driveway located on what you claim to be a public right-of-way. Is that correct?
Yes.
Okay. And that specific driveway goes in a roughly easterly to east to west direction and emerges out onto Highway 71, is that correct?
Yes.
Okay. Now, you claim that Lake Drive came into existence by virtue of Scavenger Dock number 33, with respect to that portion of Lake Drive, which is southerly to your lot 4.02, correct?
Yeah, I don't know when it came into existence. I know that it's shown on that map.
Okay. All right. So my question, I guess you've answered my question. You don't know when it came into existence.
That's correct.
Do you know whether or not it did in fact come into existence?
Well, it's shown on the official maps of the township.
Okay. Which official maps of the
The
township?
tax maps.
The tax maps. You are familiar with the concept that tax maps are not to be used for any other purposes other than for assessment of taxes. Is that correct?
I understand that.
Okay. So that's not an official map of the borough for purposes of dedicating a right-of-way. You agree with that, correct?
I don't know that, no.
That's a legal question, Mr. President.
That's fine. Now,
Wonder if anybody's been paying taxes there, if that's not a road.
lots of
No,
legal
you
questions.
still
Lots
put that-
of legal questions. Okay. Now, you, other than this specific map here that makes a reference to Lake Drive, do you, in your due diligence, determine the access for your property in question? Did you make any other findings with respect to how it is Lake Drive, or whether or not Lake Drive ever came into existence by way of the right
I'm
of
just
way?
gonna say, this has been asked and answered.
Well, obviously he's been asked and answered by you because he testified that he did and checked the adjoining properties for meets and bounds descriptions and plotted them out, which would show whether or not other properties owned it. But Mr. Brennan, I understand if you're not hearing me, but if you're arguing that there's no proper access along Lake Drive, you're in the wrong church. Not even the wrong pew, you're in the wrong church, because we're not gonna make the determination whether Lake Drive is a public right of way. That's on the applicant in another form. I don't wanna, burn wheels, so I'm gonna tell them, ignore anything suggestion that Lake Drive is not a right of way.
So for purposes of clarity, right now, the board should not consider whether or not Lake Drive is even a right of way.
They should consider it is a right of way,
And how,
because it's based on signed and sealed plans of an engineer and a licensed surveyor.
okay,
If
we're
they
trying
are-
to cross-examine.
If they are wrong, if those plans are wrong, that's their problem, not the board's determination. They're not going to make the call, and I don't understand how to say this any different, Mr. Brennan. Stop asking about who owns the right of way. The next time you ask a question that even hints at that, I'm gonna ask you to move on.
Okay.
You're wasting the board's time. You know enough about planning boards to know, including the case that was just published, this is an absolute waste of their time.
All I'm doing is cross-examining these testimonies.
Doesn't matter, it's a waste of their time.
Examination. Okay.
You could cross-examine them on who's gonna be president next, that doesn't
You
mean
can
anything.
testify.
Let's get on with it.
Just keep going.
Let's get on with it.
Now, as part of your, you referenced the title search, correct?
Yes,
Did you conduct the title search?
I did, yes.
You personally conducted the
No,
title search?
no.
Did you personally conduct the title search?
Oh, you just,
He's a surveyor.
okay, so what did you do?
So you conducted the title search?
I did, yes.
Okay. Let me direct your attention to, as part of your title search, and I want you to take your time to go through this document here, on one, and tell me whether or not you found any of these public records as part of your title search.
Can we, Mr. Brennan, we're talking about title, that means ownership, that means access, what are we doing?
We gotta move on.
At this point,
We're
I'm
not
asking
talking
Chairman
about
to shut
ownership here. That's not our purview. You know that, I know that. It is not our purview.
These are all needs, that means ownership, access, all those things that we talked about, that shouldn't be part of this.
You testified regarding a certain easement which you claimed crosses over lot 7, correct?
Yes.
And we're gonna be entitled to ask about this, Mr. Collins, or?
If you dispute that he has the right to that, it is example. It is an example of what I'm telling you, it's a waste of our
Okay,
time.
so then it was a waste of time when you put it on and by way of directive.
He claims that he has a 10-foot access easement, and he's chosen an alternative one, okay? If you don't believe he has a 10-foot access easement, is that your position?
Absolutely.
Then you've sealed the deal for this gentleman, because then he has to go along the public right of way.
That's right.
I mean, why are we going down there? That's why they're not gonna
If in
decide.
fact it's a public right of way,
Then there's a huge problem if this is a landlocked lot, right?
potentially,
Oh, huge problem.
okay,
So we're not gonna go there. We're not gonna go there.
except for the fact that it was created by,
Whatever.
We're not going there.
the September 11th, 2014 letter from Mr. May. You familiar with it?
I am.
Okay. As part of your due diligence and in preparation of this particular application, did you make a determination of whether or not, what provisions of the Spring Lake Heights ordinance were going to need to have variances? from?
Yes.
Okay. And did you make a determination with respect to lot frontage?
Yes.
The requirement is that lot frontage is be provided onto a public street, correct?
Yes.
Did you determine exactly which provision in the borough ordinance provides for that?
I believe it's number 6-1989.
Okay. Now, did you do any additional investigation to determine what other ordinances might be applicable with respect to lot frontage? And whether or not lots that come into creation in Spring Lake Heights need to be on a paved street?
No, I did not.
Okay. Did you go online to look at the borough ordinances?
I'm very familiar with the ordinance.
Okay. Did you look at ordinance 22-5.17.2?
I would have to see it in order to tell you if I have read it or not.
Okay, well, let me ask you this. Are you familiar with the requirement of the borough ordinance that each lot must front upon an approved paved street having a right-of-way of at least 50 feet?
Is
That's
that,
609, do you have a copy of
isn't
the
that
ordinance?
609?
I have actually, you can look at,
Joe mentions.
here you go.
Each lot must front upon an approved paved street having a right-of-way of at least 50 feet.
And there's got to be a paved street, correct?
That's what it says.
Okay, with a right-of-way of at least 50 foot, correct?
That's what it says, yes.
Okay. And in this particular instance, you don't have that, correct?
No, the existing right-of-way is 40 feet.
Right, and it's not paved.
That's correct.
Okay. So you're asking, as part of this application, as I understand it, to have a variance from that requirement, correct?
Yes.
Okay. And that requirement, again, presumes that there's a dedicated right-of-way, correct?
Yeah.
Okay. That's all I have.
That's yours.
You're, we're public.
Anyone else in the public wish to ask a question? Seeing none?
Okay. I'd like to bring up my next witness, if that's okay with the board.
You sir.
Mrs. Stockton, can you raise your right hand? You
Yes.
swear affirm the testimony about to this board should be the truth, whole truth, nothing but the truth?
Yes, I
Can you
do.
state your name, spelling your last name for the record?
Allison Kaufman, Coffin, like the box.
I don't know if she's, I'm a rookie here, so I don't know if she's been here before.
Oh, okay.
You know what? I'm not sure I've been to the planning board in Spring Lake Heights either. I've been to the zoning board multiple times.
So Ms. Coffin, just, we're offering, are you a licensed planner in the state of New Jersey?
Yes, I'm a licensed professional planner in the state of New Jersey. I'm also certified by the American Institute of Certified Planners. I've been so licensed and certified for coming up on 11 years now. I work for James W. Higgins Associates. We're located out of Ocean Township, New Jersey. In the time that I've been licensed and working for Mr. Higgins, I have been accepted as an expert witness in front of 75 communities throughout the state of New Jersey, primarily in Monmouth, Ocean, and Middlesex counties.
We'll accept your credentials.
Thank you very much. Ms. Kaufman, did you prepare a planning report?
Yes, I did. Okay.
And dated November 12, 2014, on behalf of the applicant regarding the property that's the subject of the application pending for this board?
Yes.
Okay, and I'm gonna, can you just hand out copies and mark it as A4?
Sure.
Ken, but I'm.
Please give one to Mr. Brennan, though.
Skipping some parts of it.
It's okay.
Good.
The only thing I'd just like to point out is on page 2 of your report, Is there a sentence that should not be here?
Yes, there is, I'm sorry.
Okay, so we'll just take that out. And with regard to the board.
There are no townhouses on this
It refers
property.
to a town, but everything else in the report is accurate, correct?
Correct.
Okay, thanks. Attorney? Have you had an opportunity to review all the plans that have been submitted on behalf of this application?
Yes, I have.
And you've had an opportunity to review the property?
Yes, I have.
Okay. Would you be so kind as to describe to the board, in your professional opinion, so I should say that you obviously are aware that it's a minor subdivision, that the relief that's being requested, and 2 variances, correct?
That's correct.
So those variances are what you refer to as C variances, correct?
Yes.
Okay. And so could you just briefly describe to the board, in your professional opinion, relative to each one of the variances, whether or not this board can grant relief that the applicant is seeking?
Yes. When we're looking at variance relief for things such as lot depth, the front yard setback, and that improvement on the public right-of-way, these are commonly called the C variances. There are 2 types of C variances, 2 types of relief that can be granted within the municipal land use law. The first standard is the C1 standard. It's commonly called the hardship standard, and that applies when there's something about the pre-existing lot, the structures on the lot, conditions affecting the lot, create a situation where strict application of the ordinance results in an undue hardship. The second standard is commonly called the flexible C standard. That's the C2 standard, and that's a standard that is applicable when the variances requested advance the purposes of the municipal land use law, and the benefits of those variances outweigh the detriments. I had been prepared to argue this as both a C1 and a C2 variance, but after hearing the testimony earlier tonight, which called into question the history of the creation of the lot and whether or not there was self-created hardship, I don't have the benefit of reviewing all of that information, so I'm going to address this strictly as a C2 variance. So what we have is a subdivision with variances that advances the purposes of the municipal land use law. One of those purposes is to promote the establishment of appropriate population densities. Now, the variance relief that's being requested tonight with regard to front yard setback and depth and the access allows for this property to be subdivided into 2 lots. This is an appropriate density, given not only the zoning, but the development pattern of the surrounding area. It also allows for dwellings to be constructed which are more consistent with the character of the immediate area as opposed to the much larger 7,000 square foot home that could be constructed if this lot was not subdivided. Another purpose of the municipal land use law that's advanced by the requested variances is to encourage the appropriate and efficient expenditure of public funds by the coordination of public developments with land use policies. Now, this particularly goes to the variance for the for fronting on an improved right-of-way. By providing the shared driveway, a private driveway within the right-of-way as proposed, rather than improving that right-of-way with a full roadway width, this avoids burdening the public with the costs of maintaining the new public roadway, which would by itself only benefit those 2 new homes. It's my opinion that the benefits of these variances outweigh the detriments. The benefits of the proposed variances tonight include providing for that population density and a dwelling size that is in character with the zoning and the surrounding neighborhood, and providing access to the site with minimal impact to the public or the neighbor. Now, the access proposed doesn't create any new public roadways, burdening the public with the cost of maintenance. It also does not use the easement on the adjacent site. Though the applicant may have the right to use this easement for access to their property, this area is the only driveway space that's currently available to that neighbor. So using it for access would make this driveway area that the neighbor uses unavailable to the neighbor. There is no detriment, in my opinion, to the requested lot depth variance, the front yard setback variance, and the improvement on a public right-of-way variance. The purpose of these types of variances, particularly the lot depth and the front yard setback variance, is to promote a consistent and pleasing visual character and a desirable streetscape. What we have here is a right-of-way that would only have these 2 lots fronting it. The properties on the other side of the right-of-way, it's the north branch of Wreck Pond. So there is no consistent streetscape to worry about. There would be no impact to the other properties along Lake Drive by the proposed front yard setback or by the lot depth variances for the 2 properties that would be created. the access that's proposed has the least impact possible of any access solution for this lot, and therefore is the best planning solution. Access is not available through the adjacent condo property to the north. Using the easement on the neighboring property would have a significant detrimental impact on that neighbor, and going out to 7th Avenue might impact the parking situation on that street. So in this instance, having that private driveway through the public right-of-way, accessing Route 71 is the best possible planning solution to provide access to this landlocked parcel. This development would also not substantially impair the intent and purpose of your master plan or your zoning ordinance. The residential density and the lot area that's proposed is consistent with what's intended and the purpose of this residential zone. The proposed subdivision technically reduces the magnitude of the lot depth variance. The existing lot depth nonconformity is much greater. It's 62.7 feet where 150 feet is required. And after the subdivision, the two lots, those still non-conforming, have lot depths of 73.22 feet, so that's more than 10 feet better, and 110 feet. So it does bring the site more into conformity while not eliminating that non-conforming condition. And the development addresses a concern that's raised in the most recent reexamination report with regard to helping the borough maintain its range of housing opportunities by providing for the two smaller residences as opposed to one much larger structure.
I just wanted to go back on a couple of quick points with you. Relative to your testimony and the 10-foot wide easement through block 73, lot 70, joining property to here.
Yes.
Is it your testimony, did I hear you correctly, that right now the property owner to there uses that easement area for his driveway?
Yes.
Okay, so that obviously it would be detrimental to him
Yes.
if that easement, you could no longer use that easement area.
That's
And it was completely in access.
Yes.
So it's obviously a benefit to him if there's access through Lake Drive.
Yes.
Okay. Now, I assume you're also familiar with the New Jersey statute 40:55D-35 and then 36 regarding development on an improved street.
Yes.
Okay, so could you briefly just describe to the board?
This is a section of the municipal land use law that requires that any development be located on a lot that fronts on an improved public right-of-way. Now, there is criteria given within the municipal land use law that allows a zoning board of adjustment to grant relief for that, and that is
And the planning board.
in the planning board, yes. Yes. And that's when it would entail practical difficulty or unnecessary hardship, or where the circumstances of the case do not require the structure to be related to a street. So that's the criteria given within the municipal land use law to grant the relief for access. And in this case, I think it's definitely applicable that the structure does not have to be directly related to a street because there is an alternative access available.
Okay, so let's just discuss that for a moment so that the board understands. Because obviously you've heard that there's an objector
Yes.
who ironically is the property that would benefit from not, the easement would being closed off, access on Lake Drive.
Yes.
Relative to the lot itself, the property owner would have a right to develop that lot, correct?
Correct.
Okay, so they would, in terms of developing that lot, the permitted use that's in the R5 zone, being with a residential structure, they would need access, correct?
Correct.
Okay, so they would have to obtain access from, one of several ways here, and based on the testimony, and I assume it's your opinion, that the best access there would be through Lake Drive, is that correct?
That's correct.
Okay. And then it is your testimony that ironically, the minor subdivision is actually a benefit
Yes.
in terms of the municipal, the master plan and the ordinances of the municipality.
Yes.
I believe you were here I should say, just for the record, did you have an opportunity to be here this evening from the beginning of this application?
Yes, I did.
So you heard all the testimony that was presented by Mr. Stewart?
Yes,
And you also heard the questions that were raised by the objectors, counsel, Mr. Brennan?
yes, I did.
Okay, so there was some discussions regarding whether or not this was a self-created hardship on this lot. Can you address that issue, please?
Well, it's a self-created hardship, and you brought up when you have a lot that's created through subdivision that creates the nonconformities, and then further development would also require further variances related to that subdivision. So since I'm not clear on the history, I didn't want to get into the hardship issues, because I don't know what the zoning was in effect at the time, or whether variance relief was granted, or if it was a conforming depth, at which point the hardship would not be self-created at that time.
But there's nothing in anything that you've seen where this lot, through any subdivision, was to be dedicated open space
Oh,
or
no.
conservation? So there
No.
was an idea that this would be a developed lot, correct?
Correct.
Okay. And the same thing, you had an opportunity to review the easement, that's the 10-foot wide easement over the objector's property, correct?
I have seen it on the plans, I haven't reviewed the documents for it.
Here's a copy of it. And then the board's also, it's been marked in.
We're not gonna let Mrs. Coffin talk about title issues either.
No, we're not going
Okay.
to. No. Just get to the questions.
Try to
On
keep
the
it
easement
straight.
here, it does reference that if there is access to Lake Drive is opened, then the easement would extinguish, correct? Or it talks about that, if there was access to Lake Drive, correct?
Yes.
Okay. So there was the anticipation that Lake Drive may be an access to these properties?
Yes.
Just for the testimony, let's go back, the easement that you've seen, first time you've seen it today?
The document, yes.
The document. You have no idea what property it relates to, do you?
I've
Without-
seen.
Without the prompting of council.
I'm not prompting, and then by the way, I can certainly point out something,
You
Mr.
know.
Brennan. So,
Do you know whether, do
She
you know whether?
testified that she saw it on the plan, and she saw the document for the first time today.
Okay, great. Let me look at the document, would you take a look at the document?
I'm looking at it.
Okay, who is it between?
If we're going back to ownership, we're not going.
Herbert L. Davis to R. Leroy Stewart?
Do you know who they are?
No.
Do you know where they
First
fall
time I've
into,
seen
if
this.
they fall into this, the history of this particular area?
No.
Okay. Now, if I understand it correctly, you're not testifying that there is a C1 variance in this business, is that
That's
right?
correct.
So you're proceeding, if I understand it, the only testimony you're providing is with respect to flexible C.
Yes.
And the flexible C, your testimony was largely that one of the benefits would be that if there was a public drive instead of a paved street, that would be one of the benefits to the town and to the adjacent landowner. Is that correct?
No, I testified the exact opposite. That if there was a public drive with a paved street, it would create more of a burden on the town than the private drive.
I think I just said the
So
same.
you said public.
no, you said
Oh,
public.
I'm sorry, my mistake. Okay, again, that presumes, does it not, that there is in fact a dedicated right of way?
It's what is shown on the plans that the surveyor has signed, so yes.
The surveyor is the applicant.
Yes.
And so that was one of the, that's part of your testimony, a large part of your testimony with respect to one of the benefits under Flex C, correct?
The benefits for not improving the right of way, yes.
And then the other thing was establishment of population density. You're saying that having two would be better than having one
That's correct.
for purposes of population density.
That's correct.
Appropriate.
Appropriate population density, okay. That's all I have, thanks.
Let me just ask one question, Ms. Coffin.
Please.
Out here. In your capacity as a planner, if the board creates a And when you assume for purpose of the question, the board created a subdivision that cut off the townhouses.
Yes.
And provided no access to this created lot. And assume that Lake Drive is not a public right of way. It provides no access to a paved public street. And let's assume for purposes of the question, there is no 10-foot access across the neighbor's property. Does that mean the planning board at some point created a wholly landlocked lot with no access and a separate lot with no access?
If all of those conditions were correct, then yes.
Could I just ask a question, follow up to that, if I could?
I'm just trying to make sure the board understands.
Do you know, have you made a determination of whether or not Lake Drive is that there's access across the properties to the east of this property in question?
No, I have not.
That's a fair question. Either side, assuming either side, it's not.
Any other questions?
I have a question.
Do you represent by Mr. Brennan?
Yeah.
Then you're not allowed to ask a question. They'll deal with it for you.
Okay, can I ask Mr. Brennan next year?
Well, sure.
If I could direct your attention to the plan. The property, the improvements on lot 7, you see them?
Yes,
Okay. There's a porch on the southern end of the improvements, correct?
yes.
Okay. The access that's being proposed is how close to that porch?
Is that an engineering question or?
It is an engineering.
Yeah, that's an engineering question.
If she can scale it, she
No, but
can.
Chuck can scale it.
I'll use a ruler,
Yeah, if she knows how to use a scale, she can answer the question.
20 feet. He won't let me hold the scale. He thinks I'll steal it, he's probably right.
And then you would be, the building.
Presuming that there is a dedicated right of way, that there can be private drive located on it, and it's being proposed by the applicant, that they locate that private drive within 20 feet of the applicant's improvement, the home, the porch. And you take into account the impacts that the use of that driveway might have on the lot 7?
It's my opinion that there would not be a significant impact having a driveway 20 foot off their porch, 12 and a half feet off their property line.
Any other questions?
Can I just clarify how the land became
You
land?
need to step up.
No, we just want, is it a question of the witnesses, or are we done with that, with the questions? Are you gonna make a statement?
Like the property's kind of landlocked and
Do you
nobody
have a
else-
question for the witness?
Do you have any documentation?
Then you gotta come, give your name, address.
My name is Jacqueline Flynn.
Into the microphone, please. Into the microphone, please.
My name is Jacqueline Flynn, I live in condos next door. And I know basically that the whole background of the whole property, Donald Ahern, and how they became, you mentioned that you don't know how the property became landlocked. I know how it became landlocked.
Well, I didn't say how it became landlocked, I'm not saying it is. The applicant's saying it's not landlocked in the sense that there's access to it, it's just
Right.
unimproved.
Okay. But
Attorney
in
Collins,
1964,
if you could just state your address.
53771. 53771, Newton Ave.
Are we, just to make the record clear, just keep it, are you gonna ask a question, or are you gonna make a statement?
Can I make a statement?
All right, just wait a minute until everyone's done
We
answering the
have to
questions.
finish questions, then you can make statements.
Okay.
We'll get to that,
Well, can I make a, can I ask a question?
of the witness.
Is there any documentation that you have that there is an easement on the property?
Not that I have, but it was provided.
Which
in
property though,
evidence.
ma'am? Which property?
Okay, lot 73, lot 7.
Um,
You have
It's,
any
it's,
documentation?
it's
that
shown,
it is?
do I, I'm the planner, no, but the surveyor does.
It's shown on the map on the north side of the property,
It's marked as A3.
A3. It's right there on that map. On the north side of the property,
But once again, so you understand, ma'am, once again, it's the applicant's problem with respect to the access, okay? If they don't have access, that's their problem. It's not for the planning board to decide whether you're right, Mr. Brennan's right, they're right. It's not for the board to decide that, okay?
any other questions for the witness? Seeing none. I guess we could open it up to a statement, and your statement essentially is you're either for or you're against. Any statements?
Or you're entitled to present witnesses and expert witnesses if they choose.
John Brennan, 42 Main Street, Amherst.
So what I'm gonna do, so you understand, so I'm gonna mark it to evidence 01, because it appears to me, because the rules of evidence are not strict in the planning board. Based on your representation as counsel, I assume you're gonna represent that these are true and accurate copies of some search you did at the Monmouth County Clerk website to provide, which reflects deed books and page numbers. Will you make that representation? Okay. To the extent that at the end of everything I tell the board what to do with this, is something else, but I think it should be marked as an exhibit 01. Okay?
Can I have a copy?
You can certainly distribute it.
May I have a copy, please?
Okay?
I'm only go halfway and then I'll go around. Does that sound right?
I gotta get one.
Mr. Brennan, you're an attorney representing a party, okay? Are you gonna try to make some legal arguments with respect to the documents that were just?
Legal
Okay,
arguments.
you're not gonna testify, you're gonna
And
make
no,
legal arguments.
I don't need to testify, the documents speak for themselves.
But if we start talking about ownership, creation of access, I'm gonna stop you, because at the very end, I want you to understand, that I'm gonna tell the board that to the extent that these purport to show a different owner, or a different access, or no access, they are to ignore every single one of these pages. You understand that?
Yep. What you have before you is the first two pages are the list of all deeds that are referenced in the planning board with respect to Ahern, and also Mayfield Manor. Mayfield Manor, you'll see, was the owner of the condominium complex.
Why does Mr. Brennan, we could say back, I mean, your records reflect since 1982, right?
No, they go way back.
Well, where?
They go back to the oldest.
Okay. Look at your instrument summary list.
Okay.
Am I wrong?
Yes, those are the Ahern documents, correct.
Okay.
Okay. The documents in the front of the package are documents by which the Aherns obtained these specific documents.
Okay, again, we're talking ownership, let's move on.
Okay, I am. I want to direct your attention to I will tell you that these documents are devoid of any reference to Lake Dock Drive being dedicated. I'm going to direct your attention to prior to the master deed, which came into existence by way of the 1983 subdivision by your predecessor board, Mr. Ahern obtained the property, and if you could look at document number 25.
What page are we on?
If you look down at the bottom,
Document 25.
page 25, down at the bottom.
That's Skellinger Dock 25, is that correct?
Right.
The top of the page says second tract.
Correct. The third tract talks about the property that ultimately becomes the subject of this application. And it talks about the ownership going halfway into the north branch of Rec Pond.
How is this?
I'm still trying to figure out, because Mr. Brennan, because the
Really,
deed,
where do we go?
just so you understand, the deed you're looking at first blush actually hurts you. Because accepting from that conveyance is the land needed for the opening of Lake Drive.
It actually doesn't say that.
Yet it says accepting so much thereof as may have been conveyed for
May
the
have
opening of
been
Lake, for
conveyed- may
the
have
opening
been
of Lake Drive.
may have
So
been
that
conveyed.
means there could be a previous deed
There could
or a
be.
subsequent deed.
There
But
could
we're
be.
talking about Lake Drive.
I
Why are
agree.
we talking about
I'm
it?
not talking about Lake Drive.
What are we talking about?
My question is this.
There's no
It's
question.
not a
between
question,
the
this is
ordinance.
statements.
Okay,
There are no more questions.
that's fine.
If it's entitled, we don't want to cut.
They claim they own halfway out into.
This is out of
No,
order.
no, okay, that's right.
All right.
It doesn't matter. That's what I'm just trying to say.
Any other statements? Seeing none.
Just another clarification for the planner.
Veronica.
The actual height of the building in R5, we have 30 feet, it could be 32. Thank you.
Well, if the board has any questions or
Does the board have any
comments, or-
questions? Or they just want to leave?
Can you ask me questions, the applicant questions over there?
Whoever you want to ask a question.
I just wanted to be clear on the, are we talking about giving a variance for the property, whether it's fronting on a main road or not?
There are several variances that, well, there's really only two variances that you need to grant generally, although there may be one or more ordinance provisions that exist. And what was told to you as part of the presentation by either council or applicant or anybody was that the copy that Mr. May has of the ordinances is slightly different than the ordinances online. Effectively, though, the ordinances say in one or two spots that you need a variance for not fronting on a public street. One says on a public street that has a 50-foot right-of-way. It's also subsumed into the municipal land use laws. Mrs. Coffin testified. There's a specific provision in the municipal land use law that applies to every community in the state of New Jersey, because there are plenty of places where properties don't front on public streets. And in order to not permit someone, in order to permit someone to either not improve it or the town to elect not to improve it, you have to come before the planning board and you have to make certain that it's not dangerous to do so, okay? So that would be a variance you grant, and you would also be granting a permit if you grant the approval. You would be granting not only the variances, the minor subdivision, but the permit to build on a unimproved street. Remembering though, that ultimately that decision, whether that street gets improved or not, is the borough's.
That goes to the council.
Right, but I just wanted to know whether we were that was one of the variances we were granted.
Correct, and even if, let's say, not even get back in the argument, even if they proposed, said, one building on going in the 10-foot easement, they would still have to be here because, well, there was a pre-existing variance, but that may have been granted by operation of law, but they still don't in any way front on a public street, so they gotta be here anyway. Even if there were one house and they argued the access, they still would have to be here before they could go forward.
So all we know, it seems good, we're voting on what we think of this presentation here, not whether the borough eventually gives them permission to have
Exactly
it.
correct.
Whether it's, yeah, that's something,
And whether whatever the other thing.
Solely to the discretion of the borough.
Everyone else approves.
the borough has other issues and other considerations that, on that are not for us. That's why they're elected and we're appointed, or at least some of us are not.
So she's saying, this will be coming before the council in the future, in the near future.
Not the approval, just the fact of whether or not they can build a driveway in the right of way. Now, you could, Mr. Mayor, you can make a decision whether, hey, I want to hear that part of it, and you may want to, you can abstain if you choose, or you can vote as a planning board member on the application. It's certainly up to you. There's no conflict between you being mayor or
I will see it again.
You're going to see it again. But remember, you're going to think about it in a different way. You're going to have your mayor's hat, not your planning board member's hat.
So we have that and the two variances about the lot depth and front yard setback, right?
Correct. Is there a front yard setback?
Is it? You know what? I thought there was-
Yeah, there is.
And just to clarify, when you make your decision, the applicant clearly stated that they were not seeking a hardship variance. They were seeking a variance under C2, which is that flexible balancing of the goods and bads. The board, I'm sure, is ultimately for them.
All righty. Any other discussion? Questions? All right. I guess I would entertain a motion to approve the subdivision with the variances, subject to outside, I don't know if we can call it outside approval?
Every approval of the planning board by operation of law is subject to outside agency approvals that are.
Subject to the outside agency approvals.
I'll make the motion.
You make that, is there a second?
I'll second it.
Mr. Chairman, before you move forward though.
Yes, sir.
It did appear that if you were going to make an affirmative resolution, you would also include as a condition of the approval that the applicant provide a design stormwater drainage plan that will be approved by your engineer, that they would comply with the outstanding comments in his report. They would also be required to add stabilization on the south side of the driveway, subject to the approval of the board with respect to zone or whatever's going to keep that going. I would wonder if that would be included in your resolution.
Yes, sir. We're going to include those
Yes,
stipulations.
I'll include those in the motion.
So that's all.
That's all, that's, we have all our stipulations and everything in
I
order.
think I covered it. You'll tell me in the
Can
resolution.
I have a roll call?
I apologize, I did not give a second.
Oh, the second was
Second.
Rob Bennett.
Mr. Capristo,
Yes.
Mr. Hackett,
Subject to outside approval, I approve.
Mayor Mechanical,
I'm voting yes.
Mr. Manger,
Yeah, we have a landlocked basic piece of property here, and we worked hard with the applicant to work out in a preliminary fashion how to handle this, and then to resolve tonight in a fashion more permanent as to how to make this land useful. So I vote yes.
Mr. Merrickin,
Yes.
Mrs. Eilenberger,
Yes.
Mr. Clark,
Yes.
Chairman Dimmer,
Yes.
motion passes.
Thank you very much, Mr. Chairman, and thank you very much, members of the board.
Mr. Stewart, you need to leave all the exhibits. I have, you have O1. You need to leave all your marked exhibits. Okay, can I just make a comment?
Yes, sir.
Members of the public, the board has approved the application. The board at its next meeting will memorialize a decision in writing that has a significant legal impact, beginning with appeal period, et cetera. So you can check with the, and you'll have the opportunity to read that resolution after they adopt it, and check with the board secretary.
I just want to thank the board again and apologize for being late. Hopefully the ride home will be less than 30 minutes.
We'll see you again beyond time.
Let us know.
You can have that, please.
Thank you.
Thank you very much.
At this time, I entertain a motion to adjourn.
I'll make that motion.
All those in favor? Done.